Good morning, everyone, and thank you for joining us today for our webinar, Creative Legacies, Intellectual Property Considerations in Estate Planning. I'm Karen McGlynn. So the speakers today are Stewart Gibson. Stewart is an associate in our personal and family team. Stewart advises a range of individuals and trustees on all aspects of personal law, including the preparation of wills and powers of attorney, trust and executory administration, and tax planning. You will also hear from Jennifer Murphy, an associate in our commercial services division. Jennifer specialises in intellectual property, technology, and data protection related matters, ranging from providing compliance and regulatory advice, conducting audits, due diligence and tailored IP strategy, to drafting and negotiation of a wide variety of commercial and consumer contracts. And to kick things off will be me. I'm a senior solicitor in our IP IT litigation team. As the name suggests, I specialise in dealing with and resolving intellectual property, IT and technology related disputes, and advising clients on issues and disputes relating to trademarks, passing off copyright, confidential information, and design rights. So as noted on the next slide, between the three of us, we will cover why it is important that due care and consideration is given to IP in estate planning, what happens to IP ownership after death, how IP assets are dealt with as part of an estate, and finally, what proactive steps you can take to manage your IP assets. I think numbers are fairly steady now, so I will start off in this session by providing an overview of what happens to ownership of intellectual property after death. So I just round off a variety of IP rights in my biography, but for today's purposes, I'm going to be focusing on what could be said to be the three most common IP rights. So that's copyright, patents, and trademarks. Although I would note generally much of the same considerations apply for all IP rights. So first of all, what is copyright? Copyright is the legal right of ownership over an original and tangible piece of work, not merely an idea. Copyright protects original, literary, dramatic, musical, and artistic work, including illustration and photography. Copyright is protected in the UK under the Copyright Designs and Patents Act 1988, which gives the framework of the rights of an owner of a piece of copyright work. Copyright arises automatically, so there is no need for the author of a copyright work to apply for or register copyright over a piece of work. A copyright owner then has exclusive rights to copy the work and issue copies to the public, as well as to perform, show, or play their work. The general rule is that copyright does not expire until 70 years after the owner dies. Copyright is often thought of as being only relevant to famous authors, musicians, artists, and though they might be those most interested in protecting their rights, copyright has a much broader remit, and it's something we likely all hold. People may have picked up some new hobbies over lockdown, such as painting or songwriting, which could qualify for copyright protection. Or with smartphones, we all tend to consider ourselves amateur photographers, and our holiday snaps, or probably more accurate at this moment in time, photographs of scenic walks could be included. The key for copyright is that the work must be original to be afforded copyright protection. As you will see on the next slide, what happens to ownership of copyright after death. So copyright will survive an owner's death. As noted before, for most works, it lasts for 70 years from the date of the owner's death, or 70 years from the date the work was made public if the author of the work is unknown. So it's important that there is provision for dealing with copyright during this time. Artists will commonly make provision for this in their wills and should do. However, it is something that we should all make provision for. If there is no will, copyright transfers automatically, as with the rest of the estate, to whoever is to inherit under the rules of intestate. However, copyright can be bequeathed. So whether this is to family or a museum or educational institution. So we would always recommend consideration is given as to how you or clients would wish these works to be dealt with. This is particularly so if there is no beneficiary, as copyright ownership then falls to the Crown as either bona vacantia, that's ownerless goods, or ultimus aeres, where there's no heir. It is then administered by the Queen's and Lord Treasurer's Remembrance, or more commonly known as QLTR. So moving on to patents. What is a patent? Well, a patent protects novel inventions or processes which have an inventive step and are capable of industrial application. To receive patent protection, the invention must be something which can be made or used. It must be new, so it cannot have been made public before seeking protection, and it must be inventive, not just simply updating something which already exists. A patent can cover machinery or methods of production, but it is not available for certain inventions, such as a way of doing business or a method of medical diagnosis. Patents are available for most industrial applicable processes and devices that can be from methods of bleaching fabrics to chemical compounds for new drugs. A patent enables its owner to have a monopoly over their technology or inventive material. It also permits the owner to generate income from licensing the technology or invention to third parties in return for a fee. Some well-known examples of patents are listed on the slide there, most of which all of us, or the majority of us, will use every day. That being the iPhone, Bluetooth, and Netflix. In the UK, patents are governed, sorry, if we could just go back one slide. So, in the UK, patents are governed by the Patents Act 1977. Unlike other intellectual property rights, such as copyright, patent protection does not arise automatically, and an application must be filed with the UK IPO and patent protection formally granted to be legally binding. So patent protection then lasts for 20 years from the date of the filing of the application. Generally, a patent will be owned by the inventor unless the rights have been assigned to someone else, for example, an employer. In the UK, the 1977 Act stipulates that an invention belongs to an employer where it was made in the course of the employee's normal duties, or specifically assigned duties falling outside their normal duties, or it was made in the course of the duties of the employee and because of the nature of those duties and the particular responsibilities arising from them, the employee has a special obligation to further the interests of their employer. And on to the next slide, what happens to ownership of a patent after death. It is possible for a patent to survive beyond the death of an owner, assuming that the owner dies during the course of the patent's registration. As noted, a patent generally lasts for 20 years, so it's not uncommon for an owner to pass before the 20-year period expires. In a similar way to physical property, IP rights automatically transfer on death as part of the owner's estate. And so it's important for you and or your client to consider who they may wish to receive this benefits. As with copyright, patent rights can be bequeathed in a person's will. It's also possible to leave a patent to a trust in a will. So this would allow for appointed trustees of the patent owner's choice to be able to determine how the invention is managed after the owner is no longer here. It also allows the owner to appoint beneficiaries of the trust, ranging from loved ones to educational or cultural organisations who may benefit from any proceeds obtained through licensing agreements. Bequeathing a patent to a trust also maintains a degree of privacy and eliminates the time and expense of that which would be associated with intestate proceedings. It's important that any transfer of rights is documented in a will, as this will require to be shown to affect the new ownership by way of an assignation. So it's a requirement under the 1977 Act that an assignment of a patent is in writing and signed by the assignor. And section 36 of the Act states that a deceased's personal representative must record in writing the exercise of their power to assent to the vesting of a patent in a beneficiary. And the final right I will cover is trademarks on the next slide. Again, what is a trademark? A trademark is a sign capable of being registered in a way which means the clear and precise subject matter of the protection is determinable, and it distinguishes the goods and services of one undertaking from those of another. A trademark can consist of words, logos, letters, colours, sounds, or the shape of goods or their packaging. Trademarks can be both registered and unregistered. As with patents, to register a trademark, an application must be made to the UK Intellectual Property Office. In order to be successfully registered, the applicant must prove that the trademark is distinctive in character, is not purely descriptive of the goods or services for which it's being registered, and if it is a word mark, for example, that it isn't a word or term that is simply a generic one used commonly in the course of the relevant trade. So the registration of a trademark lasts for 10 years, after which it requires to be renewed in return for payment of a fee. In the case of unregistered trademarks, these are protected by the common law of passing off. So if an unregistered trademark should be infringed, the owner of the mark requires to produce evidence as to their ownership of goodwill or reputation associated with the mark, and evidence that the unauthorized use of the mark amounts to misrepresentation, which is causing or is likely to cause damage. The difficulty with unregistered trademarks as opposed to registered ones is that in the case of such infringement, in order for the owner to establish their rights in the trademark, and in the case of a beneficiary, for example, seeking to enforce an unregistered trademark, this will add a layer of complexity, as that beneficiary would need to prove that they have inherited those rights. So if an individual was considering what would happen to any trademark after death, it would be advisable to have the trademark registered and any IP rights clearly identified and protected. Trademarks are governed by the Trademarks Act 1994, and Section 24 of the 1994 Act stipulates that an assignment of a trademark is not effective unless it is in writing and signed on behalf of the assignor or a deceased person's representative, giving assent to the vesting of a registered trademark in a beneficiary. And on to my final slide, what happens to ownership of a trademark after death. As with patents, upon death, a trademark will pass to the individual's estate, along with any goodwill generated in a mark, and so can be left to beneficiaries in a will. Section 24 of the 1994 Act also details that a trademark is transmissible both in conjunction with or independently of the goodwill of the business. So as these can be transferred independently, this affords a testator the option to leave the business and any associated trademark to two separate individuals. If the owner of a trademark were to die without a will, however, the trademark would automatically transfer along with any physical property to those entitled to claim on the estate under the laws of intestacy. And I will hand over to Stewart now, who will cover planning for IP rights as part of an estate.
Thanks, Cara, and thanks everyone for joining us today. I see from the participants list there are a few familiar names on there, which is great to see. My first slide is really just to try and give some colour to all of this from our perspective, some snapshots from the press of how creative legacies can lead to disputes after death. What I now hope to do is set out how you might avoid these sorts of legacies. And I would say that by way of hopefully some comfort that these people, as you will see from the names, are the super talented and super wealthy. And we don't often see disputes like these in our day-to-day practice. But I'll kick off first of all by setting out on the next slide the executory process, because in many ways the question of what happens to intellectual property rights on death is very similar to the question of what happens to other assets on death. Intellectual property is an asset, much like your house or your investments may be. And so the process, certainly parts of the process for administering those rights and transferring them to beneficiaries are the same as for any other asset. So the starting point, as ever, is actually pre the death of a person, and that's where we think you should be speaking to your solicitor and trying to understand what you can do to get your estate planning up to date, make sure that you are making provision for those assets to pass to the beneficiaries that you want to pass them to, and considering things as well like the value of those assets and the consequences of that for inheritance tax purposes and those sorts of things. So there's the initial estate planning process, but then in terms of what happens after a death, the second circle on the slide there is what I've called post-death investigations. And that's very similar to the investigation of any other assets in an estate. You would write to the relevant people, you would make investigations to try and understand the extent of the deceased person's intellectual property rights and try to attribute a value to those. Valuation of intellectual property rights is tricky, depending on the nature of the right and whether or not it has been commercialized. You may take a different approach. If it has been commercialized, that is to say that the rights have already been used or sold, and the book has been published, for example, then you might have a good basis for valuing the intellectual property right on the basis of the royalties which are received following publication of the book. Where it gets a little bit more tricky is where the intellectual property hasn't yet been commercialized, and actually attributing a value to that can be very difficult. Why is the value important? Well, that's because, like with other assets, inheritance tax may be payable on the intellectual property rights. Anything that has a value tends to fall within the remit of Her Majesty's Revenue and Customs. Intellectual property is no exception to that. So we have to understand the value so that we can understand how much inheritance tax is paid. That's important because obviously your clients want to comply with their tax obligations. It's also important from the legal perspective because satisfying the revenue that you have paid the correct amount of inheritance tax is a precursor to obtaining what we call confirmation. And confirmation is effectively the Scottish equivalent of probate. It's called probate in England and elsewhere in the world. certainly in some other jurisdictions. This exercise is really one of obtaining legal title to the property. Effectively, it involves collating an inventory of everything which the deceased person owned. So that would include, for example, their house, their car, their personal possessions, their investments, but it would also include any intellectual property rights that they have. And it's very important that those rights go on to the inventory of assets, because that is the inventory which the court approves, which the court legitimizes. And therefore, it is only assets which are on that inventory which the deceased person's executors are able to go and collect and thereafter make over to the beneficiaries in terms of the deceased person's will or intestacy in the scenario where they don't have a will. There's a plea from me at this stage. If you are talking to clients about intellectual property rights, indeed if you have them yourself, they, like other assets, are controlled by your will. As Cara has said, the vast majority of intellectual property rights can be left by legacy in will. So it's important to make sure that those are considered as part of the will drafting and estate planning exercise. My colleague Jennifer will talk a little bit in due course about distributing assets to beneficiaries. In the meantime, I hope to pick out some of the questions that you might be thinking at the moment about estate planning and intellectual property rights, and hopefully answer some of those for you on the next slide. So, first question I thought that people might ask, is the intellectual property right capable of transfer on death? The short answer to that question is, for almost all of them, yes. Cara has run through the most relevant intellectual property rights which we see most often: copyrights, trademarks, patents, things like rights and performances. All of these things can be bequeathed by legacy in a will. So the message from us is make sure that these assets are identified and, if relevant, provided for in the will. The second bullet point there is the individual still the owner of the intellectual property? I'll come on to that in a little bit more detail shortly, but the question there is, as Cara said, does the deceased person own this intellectual property, or actually is it something that they did in the course of their employment such that their owner owns the intellectual property? Or has their creative business, has that become a company in the course of their career? Does the company actually own the intellectual property rights? So there's an exercise there which ideally should be done before death, but if not, should be done after death, in ascertaining the extent to which the intellectual property, which may on the face of it be the deceased person's, is actually as a matter of law owned by the deceased person. The third question there, are there costs associated with the intellectual property right? There are, as Cara and Jennifer will tell you much more intelligibly than me, there can be costs associated with the registration of intellectual property rights and these sorts of things. And from my perspective, the reason I've put this question on there is because if you're thinking about leaving intellectual property rights to friends or family, and those intellectual property rights have not yet been monetized, then you may be leaving them an obligation, or at least the possibility of having to pay to continue with the registration of those assets. So sensible to have regard to that and ask yourself, should I be giving them the intellectual property right alongside the funds to continue to properly protect that intellectual property right? The next question, sort of similar vein, should the monetary benefit be transferred alongside the IP right? It is theoretically possible to leave the intellectual property in something to a beneficiary, but leave the monetary benefit from that intellectual property to another beneficiary. It's not something that comes up too often, but it is possible. The final question there, again, it's slightly similar to the point before. If an individual is leaving a bequest of an asset in which copyright arises, does the individual intend to transfer the copyright in that asset as well? So the point here again is that there is a distinction between the physical asset and the copyright in the asset. So quite often we will see clients who leave all of their personal possessions to their spouse or to their children or whoever it may be, and those personal possessions may include, for example, an unpublished manuscript. In those circumstances, without express provision to the contrary in the will, the copyright, the intellectual property in that manuscript would go with the book itself. If that's not what's intended, then it's important that the intellectual property is carved out and can be monetized by the person who you want to be able to monetize it. And on that note, my next slide touches on the idea of literary executors. So as I expect everyone, certainly most of the people on this call will know, a person's executors are the person who, or the people rather, who are responsible for administering their estate after their death. So that extends to everything we've talked about in terms of investigating the estate, ensuring tax compliance and these sorts of things, and ultimately transferring the deceased's assets to the beneficiaries. Sometimes, though, you might have a scenario where a person who is perfectly well suited to that role, it may be a spouse or a child, for example, isn't necessarily suited to the role of taking works on to publication. So the example we've given on the slide here hopefully illustrates my point, which is the example is Christopher Tolkien, the son of J.R.R. Tolkien of Lord of the Rings fame. Christopher, was appointed as his father's literary executor, and together with a writer whose name escapes me right at the moment, he took some of his father's unpublished manuscripts onto publication, publishing, as you'll see on the slide there, the Silmarillion in the name of Tolkien, having been based on his father's manuscripts. So the point there is just that you may draw a distinction when you're looking at wills and estate planning between the person that you think is best suited to deal with your estate generally and deal with the what might be the personal aspects of things, and the person on the other hand who is best suited to dealing with the creative literary side of things. And the point is that you can and possibly should distinguish between those two people. I don't think I have seen a particular carve out of a role for an executor other than literary, but presumably there is nothing stopping you having a musical executor or something of that sort as well. As I say, it's not something I've come across, but I expect it would be possible. The final bullet point on this slide is just about profits. And again, this is about drawing distinctions between who is doing what and who is getting what in your will. So just because you're appointing someone to be your literary executor, it may not follow that you want them to be able to monetize or commercialize the intellectual property in your manuscripts. I'm thinking particularly here of a scenario where you may have an agent or a friend who works in the same field. They may be the best person suited to dealing with the publication of the works, but you may still want your family members or your friends to benefit from the actual royalties produced from the works in, after publication in due course. So there's another point to think about there in terms of drawing that distinction. Okay, on my next slide, I just wanted to mention moral rights very briefly. Excuse me, moral rights include, as you can see on the slide there, the right to be identified as the author of a work, the right to object to derogatory treatment of that work, and also the right not to be identified as the creator of a work which wasn't created by you. These are interestingly rights that can have a commercial value. Infringement of these rights is actionable, so to speak, and I'm sure Cara could talk in a much more qualified way than myself about this, but as I understand it, you can litigate over breach of these rights. The interesting point from my perspective, excuse me, is that the first two rights are assets. They can be distinguished from the copyright itself, but generally they would come as a package with it, and those two can be specifically bequeathed. They last for the same duration as the copyright, as Cara has set out. The interesting point from my perspective is the third right, the right not to be identified as the creator of a work created by someone else. That right actually vests in the executors of the deceased person. So it's the executors who would be able to enforce that right. So if I'm honest, this slide is slightly self-indulgent, so I'll leave it there and won't say anything more about it. I want to just finish off my section with a mention of a couple of issues on the next slide, which can maybe be described as pitfalls and problems, or certainly potential pitfalls and problems, things to think about. The first point there is whether a legal rights claim may be relevant to creative legacies. The very short answer to that is yes, very much so. For those who maybe don't know, legal rights are Scottish forced heirship rules. They entitle a deceased person's children or spouse to a certain fixed share of their movable estate, and that regardless of what the deceased person put in their will. So if, for example, you were to write your children out of the will, as people might colloquially talk about, those children would still have a fixed claim in your estate on the basis of their legal rights. Exactly what that claim is depends on the composition of your family. If you have a spouse and children when you die, then the legal rights claim will be 50% of the movable estate. If you only have one or the other, that is to say a spouse or children, then their claim will be 1/3 of the movable estate. So you either have only a spouse, in which case their legal rights claim is 50%, or you have only children, again, they would share 50% of the movable estate. If you have both, then their legal rights are 1/3 each. Legal rights are a whole topic in themselves. The purpose for today's discussion is that intellectual property rights are movable assets. They form part of the movable estate and are therefore subject to legal rights claims. So the message for yourselves or for your clients is just that if you are looking at not benefiting children or spouses in wills, then have some regard to the question of legal rights. It may not be as simple as leaving your intellectual property rights to who you want them to go to. Certain people may have fixed entitlements in those. Okay, so that is legal rights. If anyone has any questions on legal rights, please, or on anything for that matter, please do feel free to pop them in the Q&A or to follow up with myself or Cara or Jennifer afterwards. The final point from me is something I touched on earlier, which is just this question of ownership of intellectual property rights. Quite often we see clients who will come to us with what they quite rightly identify as intellectual property rights in things. And there's an exercise to be done there in identifying, okay, well, do you want to pass the copyright to your friend on the left-hand side of this diagram here? Well, you can do that if you own the copyright in the, let's say, unpublished novel that you've been working on. If, however, you you work as an author and you have incorporated and you run your business through a company, it may be that your company owns that copyright. In that scenario, it would be impossible for you to leave a legacy of the copyright to your friend. But what you might do is look at leaving a legacy of company shares to your friend. So again, that creates a degree of separation. It's not quite as simple as leaving the copyright outright, but of course there may be any number of reasons why the copyright is owned by the company during your lifetime rather than owned by you as an individual. So again, the message from me on that final point is just making sure that you own the intellectual property, or at least you know how that it is owned, or rather how it is owned, so that we, the lawyers, can ensure that we make that intellectual property right pass to your chosen beneficiary at the end of the day, insofar as we can within the legal structures that you're using. On the subject of making sure that the assets pass and how that actually happens, how the transfer from the deceased person to their beneficiary happens, I'll pass you over to my colleague, Jennifer Murphy.
And thanks, Stuart. Yes, so in today's webinar, I'll cover the transfer of IP assets once the formalities of the estate are complete, and just some tips for how to manage your IP assets and takeaway points from our discussion this morning. Following on from Cara and Stuart's comments, one of the key considerations necessary when trying to effect the transfer of IP that has been bequeathed is to understand what type of IP you're dealing with, including what that consists of, whether or not the individual still owns the IP, otherwise the legacy may fail, and also who the beneficiary is. And these points are important because they're the pertinent details that need to be recorded in order to give effect to that transfer. So just touching on some of the IP ownership issues that Stewart has discussed. When considering issues of IP ownership, it's also important to understand in what capacity the IP was created, as this will help to determine whether the IP is owned solely by the individual or a company or other legal entity, or whether it was owned in common or jointly with someone else. Just to recap, as I'm sure some of you are aware, sole ownership is where IP is solely created by the individual, and therefore it is the sole property of that individual author. Whereas joint ownership typically arises when IP comes into existence by the efforts of two or more parties, particularly where their efforts are indistinguishable from one another. It can arise as an operation of law or in a range of settings, including joint ventures, artistic collaborations, shared research and development projects, and such like. The good news is that most IP rights can be jointly owned, but it is a common misunderstanding that the implied joint ownership will provide a straightforward way of organizing and the respective rights and obligations of those co-owners. In fact, in the absence of any express agreement, co-ownership of IP rights is fraught with practical and legal complexities because the rules may vary depending on the different types of intellectual property rights and across different jurisdictions where parties are utilizing those rights. But generally, on death, on the death of one owner, the rights will pass to their beneficiary rather than the co-owners. But as I said, in the case of or in the absence of any express agreement to the contrary, the use, enforcement, and transfer of those IP rights may require the consent of the other co-owners, and this can lead to difficulties where there's disagreement on how the work should be commercialized or reproduced. There may also be risk of potential infringement by the beneficiary through improper use, and also there can be disagreements about how the IP should be exploited, and a difference between the goals and objectives of those co-owners. So when dealing with an estate, it is important to clarify before the transfer, and this is some of what the executry will do, as Stewart touched upon, is to clarify what were the circumstances in which the IP was created, what IP is actually to be transferred. Is it the full IP rights or a partial IP right? For example, is there a distinction between the moral rights or the economic copyright? Is there a distinction between the goodwill and the brand and the actual trademark itself? Should that just be the royalties or the full IP right? And then also if the individual still has the right to do so. Although the creator of the IP is usually the first owner, as it is an intangible, movable property asset, it is capable of being transferred, and the circumstances in which IP was created and the contractual arrangements may mean that although the person created it, they are no longer the rights holder or owner of that intellectual property. So for example, and just to reiterate some of the points that Cara and Stewart have made, if IP is created by an employee during the course of their employment, typically that will belong to the employer by virtue of the employment relationship. So before any transfer of IP is carried out, it is important to confirm whether or not the deceased is still the rights holder, or whether there has been any transfer of those intellectual property rights during either at the time of creation, or subsequently during their lifetime through lifetime disposals. And that can include by a gift or express contractual arrangements assigning or transferring those IP rights to other people, or the likes of setting up a trust in which you place the IP and the assets associated with it. And that can include setting up a holding company or a trust, as I said. When you are considering the underlying arrangements, contracts should, in theory, set out the intentions of the respective parties, and they can overwrite the general presumptions about ownership. But when considering whether any IP has in fact been transferred, it is important to check any contractual arrangements or legal documentation that exists in relation to that IP, and to confirm what it says about ownership, if there are any restrictions on use or commercialization, whether there's any ongoing benefit to be derived from any income streams arising from royalty payments, and or whether there are any restrictions on any successes or assigns, or whether you need consent from the other parties to do particular things in relation to that IP. All of this is obviously going to be contingent on what has happened during the lifetime of the individual, and any contractual arrangements that they've entered into, and will vary on a case-by-case basis. I think the other just important point is to pick up on something that Cara said in terms of originality. There is obviously something perhaps obvious to most of us, but if the individual is trying to leave something in which there is no intellectual property right, that of course cannot be transferred. There is a basic requirement that there is something that is original or novel, as intellectual properties protect the expression of the idea, not the idea itself. So we just need to check. It may seem obvious that what they're trying to transfer or leave behind is original, and there is in fact any intellectual property right which is capable of being transferred. So just to recap, the key issues here are whether there is actually any IP to be inherited, whether the deceased is still the rights holder, but another key consideration is whether or not there is anyone actually left to benefit from the bequest. Cara also touched on this, and it's just to confirm that if there is no heir, what will happen to the IP. If the deceased is domiciled in Scotland and dies without leaving a will, and there's no known or traceable relatives, their assets will fall to the Crown as ultimus heiress, or the last heir, or where IP has vested in a company and the company is dissolved by virtue of the death of a sole director shareholder, then that will fall to the Crown as bona vacantia or ownerless assets. And in those circumstances, the Queen and Lord Treasurer's remembrancer, or the QLTR, much easier to say, acts on behalf of the Crown as an agent in Scotland. And once any debts or expenses have been paid from the estate, they will manage the ownerless assets, or they'll act as the last heir in respect of that property. So they can administer and license any rights in relation to any IP and collect any royalties or payments of license fees which may be granted in respect of that IP. If a beneficiary subsequently comes forward, though, there can be an application made to the QLTR, but that will only be paid out if if the QLTR's policies and procedures are complied with and followed. Moving on to my next slide, provided the deceased does in fact own the rights in the IP and there is somebody to inherit it, it will form part of the deceased's estate. And once confirmation is granted, the executor will have the authority to uplift any property belonging to the deceased and to administer and distribute that in accordance with the will, or in accordance with succession laws in the event of intestacy. Assuming you've left a will, the IP will vest in your appointed executor. If you have died intestate, the court will appoint an executor dative through the confirmation process. And once you have an executor appointed, the IP will vest in trust to that executor, and they will then assign the IP to your chosen beneficiaries, or the beneficiary under a legal or prior rights claim. The important thing for effecting a transfer is that the assignation of any intellectual property right is in writing from the executor to the beneficiary. Under Scots law, an assignation results in the executor transferring the deceased's interest in that intellectual property to the beneficiary. Therefore, you can only assign what someone actually has rights to, and which is why we've stressed the importance of understanding the ownership of the intellectual property at the time of death. Any assignation can also be in respect of an absolute or partial transfer in the title and interest in that intellectual property. So again, it's important to understand what that intellectual property consists of. For example, trademarks can be partially assigned in respect of specific goods and services or in relation to specific territories. And likewise for portfolios, because it's in fact a portfolio of different rights, which include personal and economic rights, you can make a distinction between the two when you're making that transfer. And it's important to remember that the assignee will inherit both the benefit and the burden of that intellectual property. So another thing to check is the underlying contractual provisions and any formalities in relation to those contracts, because as a property right, you can grant securities and mortgages over intellectual property, so there can be further encumbrances on that intellectual property, which would need to be reflected in any subsequent assignation. You also need to check that any underlying contractual arrangements in relation to that IP don't include any restrictions on the transfer or require the consent of any other co or joint owners, in which case that may also need to be addressed in the assignation. So that, I suppose, to the greatest extent possible, you are reflecting the intentions of the individual who has passed away. Then finally, in relation to any registered intellectual property rights, you will need to update the relevant registry. In the UK, that's the Intellectual Property Office or the UK IPO. They will need to be notified of the change of ownership, and that usually consists of completing a form and payment of a fee. It's relatively inexpensive in the UK. In fact, it's around £50 to do that. And the beneficiaries may also wish to file with the form the assignation itself or a confirmatory assignation. Sometimes parties will prepare a short form confirmatory assignation where the details of the assignation itself are particularly sensitive or commercially you wouldn't want the public to know what level of royalties were being derived from the IP, for example. So the important thing to do in order to transfer your intellectual property is to have that written down in the form of an assignation and or together with a confirmatory assignation if you want to register that change of ownership with the UK IPO. Another important thing just before we move on is to seek advice from IP specialists in different territories if the intellectual property is being used outside the UK. Intellectual property rights are territorial in nature, so they will have different legal implications and laws governing them in different territories in which they are being used. So once you've done all of that, hopefully you can happily say that you've transferred that IP to the intended beneficiary. So moving on to my next slide, and conscious of time here, just a quick overview of what you can do to try and manage your IP during your lifetime and to ensure that there is a smooth process when you are leaving that IP to somebody you want to inherit it. So just in general, be aware of what the IP is. Create an inventory of the IP and your digital assets that you hold during your lifetime. Without prudent record keeping and copies of the legal documentation, it might not be unequivocally clear who is the actual owner of the specific rights. Plan, if you have any IP, what you want to do with it during your lifetime or in terms of any legacy. That can include registration. If you can register your IP, consider whether or not it's appropriate for you to do so. Particularly if it's an unregistered right, then you may also want to just make sure that anybody who's inheriting it understands the value in the unpublished or unregistered or unproven IP, as that might not be apparent to the intended beneficiary. Think about maintaining your IP. Stewart touched upon this as well. Payments are due in respect of renewals and maintaining your registered intellectual property rights. And generally that's every 5 or 10 years. So if you don't maintain the IP, you could lose that right. And when you consider beneficiaries, consider whether or not the intended beneficiary has the means to continue to maintain that, or whether any specific provisions should be made in the will to allow them to maintain the IP. Consider the different types of intellectual property at play, so whether that's moral rights, if there's personal rights that you want to assign to beneficiaries, or whether there's other sort of economic rights or splits, as we've touched upon before. Think about lifetime disposals. As I said, you could sell your IP and distribute the proceeds during your lifetime. So you can give that to cash to someone as a gift, but obviously being aware that any gifts made within the last 7 years of your life will be subject to inheritance tax. You could assign the IP directly to your intended beneficiary. But as noted before, this would need to be in writing and properly recorded. You could set up a lifetime trust. So another option that we've maybe not touched upon, but I think was raised perhaps as a question throughout this morning's talk, was setting up a lifetime trust to ring fence that IP and those assets. So the intellectual property rights would be assigned to the trust and can protect the IP assets and rights attached to it during the lifetime of the individual and also on death. You can leave you can appoint trustees to administer the trust, and you can leave it specific instructions on how to administer and transfer that IP. The trust can also appoint beneficiaries to benefit both during the lifetime and after death. Other things to think about include exploitation arrangements, so maximizing the value of the IP during your lifetime, and understanding what's likely to happen when you do pass away. Do you want to set up licensing arrangements or other contractual agreements to deal with commercialization and exploitation of the IP? What income streams can you derive from it? Planning for any restrictions that may be imposed as a consequence of those licensing arrangements, and also to consider what the value of your IP is likely to be. If your IP is going to comprise a large part of your estate, then it's a good idea to obtain a formal valuation, which would require specialist input, because IP, when you create it, doesn't really have much value. It's only through use and through exploitation that it will gather in any sort of value or demonstrable value. Then you will need to take advice on what the market would fetch for the IP in question, and that's quite a complicated exercise. So we would recommend that you seek specialist advice. And just in general, to say that planning limits the upheaval after death and gives a bit more clarity and peace of mind that your IP will go to the person that you want it to. So we would recommend, as solicitors would normally do, to make a will. It may seem obvious, but if you're mindful of what will happen to your IP when you die, and plan how to that is dealt with, and this will give you a lot more control over how your IP is used subsequently. So when making the will, just obviously be mindful of the IP that you hold, check any ownership issues, consider the different rules that apply to the different types of IP and the protection in question, whether there are any territorial or jurisdictional issues that you need to consider, how the IP will be distributed, whether that's in full or partially, and decide, as well as deciding who to inherit. Careful planning can also mitigate the potential inheritance tax liabilities on your death. You can also consider potential restrictions on how the IP is going to be used. And I've referenced quite badly a lyric of the Beastie Boys, but Adam Yonch was the MCA of Beastie Boys, and when he passed away in 2012, he added a handwritten codicil to his will, albeit this is governed by US law. So there's some slight peculiarities and differences that would arise, but he had originally left a will saying that the rights to use his image in respect of any commercial output would be restricted, but he changed that to say that the use of his image, music, and any art he created would be restricted, in an attempt to prevent from others capitalizing on his creative outputs. And in fact, this is quite an interesting example of somebody who didn't understand what their rights were and what the underlying intellectual property rights were. There's a difference between image and publicity rights in the US and the actual copyright. So he had inadvertently restricted his beneficiaries on how they could use that, but the co-owners of any of his music were still entitled to commercialize that, and it it led to subsequent challenges and complexities. So it is important. I know we've stressed that point, but it's just something to bear in mind moving forwards. And then finally, some other practical steps would be to, as I said, to create an inventory of your IP, and that would include personal assets, login details, and perhaps a list of passwords. Digital assets is almost a topic in and of itself, so not within the scope of today's discussion, but it is important to bear in mind what that is and how that will be treated on your death, because that can be an unintended and quite an emotional thing to deal with for any beneficiaries. Just a word of warning though, if you do leave a list of inventory and passwords, be careful that you don't use that password, because you could be in breach of the Computer Misuse Act 1990, in the same way that an executor is not able to access the deceased's bank account even if they know the PIN number until confirmation has passed. There can be certain restrictions in the terms and conditions in each social media platform and digital asset platform, which would prevent you from accessing that if you're not in fact the holder or the owner of that account. So just to check the various terms of your social media and digital assets accounts. So yeah, it's just something to, again, to think about. And if all else fails, come and speak to a solicitor, and they might help to give you some advice in relation to what to do. So in conclusion, specific and express instructions, planning, attention to detail, understanding what you've got and who it's going to is a way of ensuring that the transfer of your IP after death goes as seamlessly as possible, and wills and other testamentary instruments, including transfers during your lifetime, should provide greater control over how you deal with your creative legacies. So on that note, I open us up to any questions. I know we've got a little bit of time. Don't know whether, Stewart, do you want to take the lead on this?
Yeah, of course. Thanks, Jennifer. I'm very conscious of time. There are a couple of questions here which I can hopefully answer quite quickly. The first one is, if the IP is a trade, such as a self-employed writer working as a business, would it not come under business property relief and be exempt? That's a really good question. The short answer is, well, firstly, there's a distinction to be drawn there between business property relief provides a relief from inheritance tax that is different from an exemption. That's not just a lawyer being pedantic. There is a point there that we require HMRC to approve the relief rather than an exemption, which is effectively automatic. But yes, absolutely, in theory, if you're working as part of a business, the intellectual property is part of that business. There's no reason why it can't claim business property relief, provided it satisfies all of the other requirements for business property relief. So hopefully that answers that question. If anyone wants to follow up on that afterwards, please do give me a shout. I'm rushing through them for the sake of time. The next question was, could you put IP rights into trust to prevent a legal rights claim? Yes, again, yes, possibly. You have to be a little bit careful around that. There is some precedent for doing things purely to defeat a legal rights claim. If you do things only to defeat a legal rights claim, that can be reducible by the potential legal rights beneficiaries. But yes, if you have legitimate other reasons for transferring your intellectual property into a trust, and whether that be for inheritance tax planning, whether it be for some sort of business reason, then yes, once you successfully get your intellectual property rights into a trust that is held by the trustees for the benefit of the beneficiaries, not part of the deceased estate, and in theory not liable to legal rights. But as I say, you want to be really careful around there, that sort of caveat about not doing things solely for that purpose. Sort of similar to the general anti-avoidance tax rules. If it's just for that purpose, there's a risk of the whole thing being unwound after death. But certainly good things to think about, and things we're very happy to talk about. If anyone else has any questions, do please pop them in the chat. Otherwise, I think, given the time, folks, unless Jennifer or Cara, you have anything to add, I think we'll let you all get back to the rest of your day. Thanks, folks. Take care.
Thanks very much.
Thank you.